At some point in the course of your renewable energy project, you will have to consider the question of planning permission. This prospect fills some people with dread, but in reality it's not as bad as all that, though it does help to be organised and patient.
The good news is that not every development needs planning permission. In the case of renewable energy, quite a few of the smaller and less conspicuous technologies, like solar panels, heat pumps and wood-burning stoves, fall within the category of permitted development, meaning you don't need to submit a planning application. But beware, in many cases, permitted development rights only apply to single dwelling houses. So, if your proposed solar project involves a block of flats or a community building, you may still need to get planning permission. The same applies to non-domestic buildings, listed buildings, or in some conservation areas. However, the rules are continually being reviewed and updated, so you should always check with the planning department of your local council just to be on the safe side, even for a simple solar scheme.
If you do need planning permission, and you certainly will for larger projects like wind turbines, district heating systems, you will need to submit a whole series of standard forms. These include site plans, ownership details, plans showing the layout and landscaping proposals, and design and access statements. Your council will obviously be able to provide you with advice, guidance notes and a checklist to help you complete the application, making sure you have all the necessary supporting information. You can also turn for advice to the government's planning advice website, the planning portal. This contains lots of information and support, as well as tools to help you generate standard site and location plans and make an estimate of the likely planning application fee.
For more complex applications, you may also be asked for technical and scientific information. This will vary from project to project. A small heat pump scheme could need very little supporting technical detail. On the other hand, a large wind turbine application could require a full environmental impact assessment, including ecological surveys, noise impact assessments and visual impact assessments, all of which would need to be carried out by qualified professionals. Finally, your local council will have a statement of community involvement, which will state if you're required to carry out some pre-application consultation with the local community. For any major scheme, you should always be doing this anyway, but it's a good idea to make sure your plans tally with what the council would ask of you.
As for costs, councils operate a sliding scale, depending on the complexity of the development, around £150 for a solar panel on a single house to £7,000 for an application for a large-scale wind turbine. There are two main types of planning application, full and outline. Full applications are the most common and require the submission of all details on the proposal. Outline applications don't require all of this and are used to find out whether a large-scale proposed development, like a wind turbine, is acceptable in principle. Your local authority can advise on which type of application is appropriate for your proposal.
Once submitted to the local authority, the application is checked to make sure it's valid and then added to the planning register. It will now be in the public domain, so if you haven't done any consultation, you may now have some explaining to do. Once registered, it will be allocated to a dedicated case officer who will become your main point of contact in the planning department. It is worth keeping in touch with your case officer in order to understand how your application is progressing and allow you to plan for alterations you may need to make. The case officer begins by consulting stakeholders, including neighbouring households. This isn't like the consultation you will have done or should have done, rather it's the legal process of putting up the planning application notices you see on telegraph poles and notice boards, and contacting organisations that have a right to be consulted, like the parish council, English Heritage, and local utilities such as the water board or electricity board, depending on the nature of your planning application.
While this is going on, the case officer will conduct at least one site visit to assess the potential impacts of your proposed development and consider how they meet the council's broader planning policies. Applications are supposed to be determined in accordance with the area's local development framework. But there are times when this can be overridden. The first of these is when your council has produced an additional planning document within the local development framework dealing with a particular theme, such as renewable energy. These are called supplementary planning documents. Then there's national policy. If central government wants to encourage certain types of development, and at the moment renewable energy is one of these, this can trump the local development framework.
Decisions on planning applications are made either by planning officers, who are paid staff of the council, or by councillors, the people we vote in at local elections. As a rule, planning officers approve or refuse planning permission for smaller and simpler applications on behalf of the elected councillors. This is called a delegated decision. The criteria vary from council to council, and your planning officer will be able to tell you if yours is such a case. Usually, you'll then be advised verbally or by email what the decision is before it's formally issued. The larger or more controversial applications, especially ones which have received a large number of objections, go before a planning committee made up of a panel of elected councillors. The meetings are held in public. Here, the committee considers a report prepared by the case officer and usually follows the officer's recommendation to either approve or refuse the application, although there is no obligation for them to do so. The planning committee can also insist on making the decision on an application that would normally be made by a planning officer if they think it's appropriate. Either way, all decisions are ultimately decisions of the council.
You can appeal against refusal of a planning application on several grounds. Firstly, what is known as non-determination. This is where no decision is reached within a certain number of weeks, which ranges from between 8 and 13. You have the right of appeal to the Secretary of State, and the decision-making power is then removed from the council and given to the Planning Inspectorate. Secondly, if your application is refused, you also have the right of appeal. You'll be made aware of the procedure for your right of appeal when you're notified of the decision.
You can base your appeal on procedural errors, which means that you can prove that the council did not follow procedures properly. For example, if they forgot to consult with the relevant party. Or you can base your appeal on substantive errors. This is when you argue that the council made mistakes in deciding the application. For example, they interpreted their own policies incorrectly, or they failed to consider relevant national policy. In submitting an appeal against the refusal of planning permission, you must seek to address the reasons for refusal, as stated on the decision notice, and you should be aware that preparing an appeal will cost you money. This will vary depending on the type and size of application. Congratulations! You're almost there, but you're not over the finishing line yet. If your application was particularly contentious and there was significant local opposition, objectors could apply to have the decision overturned via a judicial review in the High Court. They have to do this within 3 months. It's a serious and fairly expensive undertaking, and this time they would have to prove either procedural or substantive errors had been made. Objectors must present a written submission to a judge who will decide if the appeal can proceed to court. If it can, and the objectors win, your grant of planning approval will be quashed. You then have to decide if it's worth reapplying to the council. They may not wish to override the High Court, but even if they do, you may ask yourself if you want to continue in the face of widespread or powerful local opposition. Finally, remember that your obligations under the planning laws aren't over once you're granted planning permission. Attached to it will most likely be a series of conditions which you must adhere to before you begin building and once construction is complete. Submitting material samples to the council for approval, for example, or a limit to the number of fuel deliveries a week. But as long as you have met the appropriate ones and are happy that you can operate your scheme within the rest of the conditions, then go ahead and get installing. Thanks for watching.